Why don't we do this, Daniel? I'll just say where we met, and then why don't you tell the audience who you are and what you're doing? So I'll tell you, I was at a conference it was at the University of Tel Aviv, wasn't it? I think it's right there. Yeah, exactly. And during Cyber Week in October's coming up, and this amazingly passionate, overtly friendly human being came up to me and just said hi and started talking, and that was you. And we've been friends ever since. Daniel's got very interesting line of work because, of course, I'm with Checkpoint, as the audience I hope would know by now. So, we deal with all things as a manufacturer. But Daniel runs a couple of businesses. He is, in fact, a lawyer in Manhattan that works with the Journal of Law and Cyber Warfare. He also works within cyber warfare, teaching litigators and lawyers and adjudicators about cyber and cyber precedents. Daniel, I think you better take it over from there because I find your world very exciting, my friend. Who are you? What do you do? And how did you get into this thing?
All right. So first off, thank you for the opportunity and the privilege. It's always an honor, and to speak with you as well as to your audience. It's always a privilege. My background, I'm a serial entrepreneur. Then I picked up a law degree, and I've always been a serial entrepreneur. I actually am a neutral with JAMS, where I arbitrate and serve as a mediator and resolve very large disputes, partnership. But my specialty is serving as what we call forensic neutral, or as cyber mediator or arbitrator, where I focus on cyber data breach driven issues. I also so happen to work extensively in the forensic neutral space doing actual forensics. So using X-Waves, FTK, you pick the flavor of the day, looking at firewall logs from Checkpoint and everybody else, working my way backwards as a forensic neutral, appointed either by the courts or appointed by the parties in an arbitration. So, you have to know the law. So I also work extensively as an educator in law, in cyber warfare and cybersecurity. It's always a privilege and honor. And I also work co-founded a global legal engineering firm. So you kind of need all three areas to sort of make it all go at once. In my specific area, we look at very complex issues, private corporations, people there's these crazy bills in Congress, like letting people hack back and other nonsensical things that are generally a bad idea to let any human without some sort of oversight engage. But we are involved in a lot of helping corporations, private and public, and governments and their institutions figure out what is the appropriate course of action. And then in the last 3 years, it's become very sexy. I guess the DNC hack really launched into the mainstream, bringing state actors and what they can do. Now, espionage has been going on since the dawn of time. Americans, we don't like it when it's done to us. But regime change has been a staple of every government since the dawn of time, right? And cyber is another tool to facilitate that, and cyber is a risk. There's a big divide or gap in knowledge, right? How many lawyers know how to configure a checkpoint or pull the logs or block an IP or a VDK or anything like that, right? But they're creating legal frameworks to determine courses of action, right? And it's a totally different world, right? I mean, even with bullets or nukes or whatever, there's always a physical trail in the digital world, attribution and all these things. And then Russia explodes onto the scene with the DNC hack, creating like a very large focus, both domestically and globally, about regime change, about, what is too far. If you go back to 2007, 2008, you have the Georgia incident where Russia, before they invaded, basically took the country, effectively a large part of their infrastructure, offline and then invaded them. Now, that wasn't considered an act of cyber war. So these are the complicated issues, because a bank is actually a private institution. So then what's the bank's right of recourse, of defense, when they're being attacked by a state actor? Who's the role? What's too far? And, when you're a private organization, you have shareholders, and then you have insurance companies and insurance carriers, and who's going to reimburse. And acts of war became really front and center when you then proceed to like a NotPetya sort of situation that basically razzle dazzle, or however you want to put it, caused quite a bit of monetary harm. And, elevated the visibility of CISOs, of course, across the boardrooms, along with Security Exchange Commission and every other major regulator. But it really increased the visibility as to what is our obligations as a corporation, right? I mean, what can we do? What can we not do? What is too far? And we're global. So all these issues come into one big problem because you're a corporation. You run a company. Your job is to make money. So how do you manage that risk? And, how do you resolve conflicts? And you're ranging from you hired a vendor to remediate, and they miss the entire hack. And fast forward, you go back online, you're fully taken offline, but it's done by a state actor. So the carrier denies coverage and you're left with like $30 million of expenses and your business is harmed. So all of these things sort of come together in one shot. And then that's just the United States. Every country around the world has their own game plan, their own rule book. So you operate in Panama, you follow the rules of the Panamanian government. You operate in Costa Rica, it's the Costa Rican government. You operate in Germany, it's the German government. Vietnam. And they all have their own authorities. And it's really complicated because the United States is running cyber operations like every government is. So is China, so is Brazil, so is Mexico, so is Canada, right? Everybody runs cyber operations. So how do you work together and secure these things? And, people talk like it's some easy peasy, black and white process, but it's super complicated in the law. And then then the privacy happen. And then it's like CCPA, GDPR, look, they're all very valid points of view and perspectives, but it makes it inherently complicated to help companies advise and manage the risks. So I sort of operate in that space of helping, companies either resolve large conflicts and figure out the appropriate course of actions and, mediate and resolve them, or working and doing all the technical forensics to figure out, did this company, who took their IP and etc. So it's interesting, never dull.
Wow. So there's so much to unpack there, Daniel. So thank you. Let's start with this. You mentioned a couple of times that, how far is too far? Some companies go too far. Give us some examples of that. What are some of the seemingly stupid things that people might do under the emotional duress of a hack or of a potential attack?
Yeah. So people think that you have a right to hack back and you don't. It's illegal. It is a crime. You leave your network, you can be prosecuted. Whether you are or not is a relative different conversation, but hacking back is just, so the best way to look at it, the stupid things I've seen are, running honeypots, but they put in the honeypot malware. And they think that's funny, but then they drop the malware and it's to one of their competitors, and their competitors are victim too, and they just basically took offline, caused harm to their competitor. We'll leave it there, and, or they think that they'll, go back and they get all these credentials, and then it turns out that they're probing their competitor systems and not the hacker systems, or they retaliate, and you can't compete with the government, right? Because the government is able to operate in a sort of unfettered fashion, up to a point. There's thresholds, right? I mean, if you impact the sovereignty of a country and you change the votes on the voting machine, that's different than posting on Facebook that blah blah, disinformation, right, or information.
Right.
But corporations are hamstrung. You're not allowed to do nothing, right? I mean, you're allowed to watch the fire come to your walls. And once it starts burning in your building, you can then act, right? The firewall should be seen as sort of, or the perimeter, however you define your perimeter, whether you use some combination of firewall and SOC and whatever, endpoint, whatever it is, Falcon, whatever you're using, right? That's your perimeter. And your perimeter, it has to be within your perimeter. So they're attacking your perimeter. You can repel the attack, but you can't go outbound. And companies that do risk, obviously criminal. There's been cases where large corporations have sued other large corporations for hacking, each other. And it's pretty outlandish, but it happens. And the problem is the CISO, a lot of chief security officers are good technically, but operationally and from a business perspective, which is cyber at a very high levels of risk. And how do you work with legal and manage you're managing a battalion or a troop. If a company is an army, you've got a division, and you've got to manage your division, but you've got to communicate with the entire army so you can effectively protect your entity, right? And not bring harm to you. But I mean, all sorts of things, or encrypting, there's all sorts of things, you can't launch retaliatory attack, like a retaliatory DDoS, or exploding malware. Another thing that happens sometimes, people put in and I know it's frustrating to corporations and to CISOs to know that they can't do anything but put out the fire. But I mean, the best analogy is if someone breaks into your house and robs you, and you shoot them while they're robbing your house, that's one thing, right? In different states, it's legal. In other states, it's illegal, homestead defense and whatever. But if they run out of your house and they run into your next door neighbor's house and you run in hot pursuit and you see the guy go in and you have a gun with you and you shoot that person, you shoot somebody in the other house, but the criminal went out the back door and you shot the guy's brother-in-law, he might be really excited at some level. But at the end of the day, you just committed murder. And there's no defense that I shot the wrong guy, right? In the cyber law, it's the equivalent. There's some U.S. laws, and that's just the United States. So every country has some variation of this and some legal parameters. Now, it gets very complicated because in some countries, the state works very closely with private corporations. So, and in other places, like most corporations in the United States can't go to the NSA or anybody, any government agency, be like, can you please just hack these people back, please? It's right. The state alignment with the corporate interests is different in other countries than the United States. But as a U.S. company, you're bound by U.S. law. As much as that may frustrate you, you have the benefit of living and experiencing the benefits of the U.S. legal system and the U.S. General system. So you have to follow and comport yourself with those laws. So it makes it complicated because, it's frustrating. You can do something, but you're hamstrung from doing it.
You mentioned a few moments ago that, the need for lawyers understanding, or at least you said it's not common that lawyers would understand the technical abilities of pulling logs from say, a checkpoint firewall or some kind of other firewall. Now, is that important for chain of custody? Talk to us about the fact that...
So why it matters is attribution, so data exfiltration, okay? So let's say we find that Cobalt Strike was dropped on somebody's active, like domain controller, okay? Or Cobalt Strike was dropped on a file server. Now you see activity of Cobalt Strike, you see zip files, you have the MITRE attack framework where they'll say blah, blah, blah. But you may want to be cautious and validate the findings, right? Because you caught them midstream. Rare, but let's say you did. And you say, okay, well, let's look at firewall logs to see if there's any internet traffic to the command C2s, right? Or whatever. So as a lawyer, you would want to ask for that information to validate for additional data points to validate data may or may not have been exfiltrated. Because the way this all bubbles up is you go to the general counsel, you go to the CEO and the board, right? And you want to say, okay, well, we dump the virtual images, and then we dump the machines, and then we pulled the firewall logs, and we saw the following journal entries, and we saw the following X, Y, and Z entries. And because of the composite set of information we saw, we can we believe with some high degree of confidence that data may or may not have been exfiltrated. Well, as a lawyer, if you don't know to ask for these things, unfortunately, not everybody has their own duty. And a lot of, managed service providers and solution providers may not think to provide you that information, or they'll tell you you're breached and you'll say how or why, and they'll say, oh, the logs. Well, there's a big difference between the journal entries and the checkpoint logs with data packets being captured to the C2, right? And so understanding what different logs mean and how they operate. Now, you can get all of this information over time, but when a breach unfolds, it happens in real time. You're making these calls when you're on the phone talking, or you're, as a legal engineer, which is where I function a lot, is you're really being tasked to help navigate that. And then when you're mediating, which is where I spend a lot of my time, and trying to, where everything's gone sideways, everybody sued everybody, and now they want to resolve the dispute, they'll come to me, and all often the lawyers will put in their briefs, oh, we were hacked and this could have been prevented. And I'm like, okay, I'll give you a great example. There was a denial of coverage claim because they said it was over 24 hours. There were 7 distinct, so basically they were running their firewall properly and they had failover working, right? So they could drop traffic. So every 2 hours they would drop traffic, but it would slow the e-commerce portal down. So they said they were 7 distinct incidents. So I'm mediating this, and you're sitting there and you're like, okay. So I go to the parties. I go, well, has anybody actually looked at the logs and the IP addresses for the actors to see if they were coming from the same IP address for the denial of service attack? Because the lawyers hadn't mentioned it in their papers. And remember, as the mediator, my job is to get a deal done. My job is to put this conflict to bed so everybody can go home and go forward with other things. So they said no. So I said, okay, well, can someone pull the logs? They pulled the logs, and they did its trace route, and we got lucky, and it went back to the Ukraine to this one address, and all 7 distinct incidents went back to the same, IP range, right? So then I go to the insurance carrier and I go, you know what? The odds in 24 hours an organization's hit by the same IP range with a denial of service attack is very low. You're probably going to lose this. And so their claim of X millions of dollars has not only merit, and they say, well, show it to me. So I had the lawyers get the logs. We highlighted in yellow. We gave it to the insurance carrier, their counsel, their experts. They read the logs and like, they met, they conferred, and then they went from, the initial demand was, for tens of millions of dollars, and the insurance carrier was like, we'll give you $100,000 was their opening count, initial offer. They went from the $100,000 to well into the 7 figures once they realized the details. But lawyers that don't know those things, as the mediator, my job is to make a deal. So we settled the case, right? I settled it for the parties. But if I hadn't asked for those logs and hadn't shown the insurance carrier the necessary information, there's no way it would have settled, right? And I get where the carrier is coming from. They want to see proof. They want to understand the tangible issues, right? Same thing with like crypto mining and, all these other things. And so it's very important for lawyers, especially that are mediating or resolving these types of disputes, to have that knowledge. And I can give you other examples in like arbitrations and other things.
This is why I'm so excited to get you on this call, Daniel, because in my world, we've got an incident response team, right? So somebody's under a ransomware attack. In fact, I was just reading the news this morning. I've closed the page, but there's a school district, Fairfax County School District is a $3.6 billion school district. It's just got hit with ransomware. So we have this incident response team. We always say first phone call's free because it's a very emotionally taxing, situation.
Yeah.
So give us a call. We'll get in there. Now, we're technical guys. We're technicians. What are we not thinking about? What would you advise the customer that's under attack right now? What's the first thing they should do? We say fix it technically, but maybe there's something right.
Take a breath. Remember, it's a risk, and you run a bit like it's like any other risk, like COVID-19, right? You were able to teach school maybe completely ineffectively and whatever, but nonetheless, you believe you're teaching school. And the people that paused and took 30 seconds to say, okay, this is a risk. Let's take stock of what's going on, right? Let's not just hire every possible vendor. Let's do a methodical, and then most importantly, don't hire them without counsel so you have it by privilege. So, I was mediating a case where they didn't use a law firm to hire the vendors. The vendor was hired directly by the IT CIO, and they had a lot of what we'll say conversations about remediation and about Active Direct, whatever, about different things that they probably, but because it wasn't retained by the lawyer, they tried to assert attorney-client privilege. And, I told them there's no way that this will apply because you weren't retained by them. There was no lawyers on any of your communications or nothing. And so your entire response to the incidents is you're going to have to provide it. So they provided it, and then they lowered their demand. But the point being, and that has long-term implications, right? Because, if you have, emoji face in the middle of a breach where you say, can you believe the Active Directory is configured like this? And they emoji with a smile. Well, let me tell you something. If that's not going to end up being privileged, first off, never emoji. Okay, never respond. Like, use the phone. In a breach, use the phone. Okay, and don't let your vendor dictate these things. Right? I mean, all too often the vendor wants to send you a treaty. No, pick up the phone and call me and explain it to me and use the attorney-client privilege. So you take your breath. And then ransomware is a sticky situation, and you've got to listen to your stakeholders. I mean, you've got to get a PR firm involved. You've got to solve the problem, no question about it. But if you've got skulls and crossbones on your computer screens, There isn't some rapid solution that's happening in the next 24 hours, 95% of the time, right? So taking a 15 or 30-minute pause, getting everybody to take a breath and engage and get the counsel involved and the other things will allow you as a CISO to also have a lot more control and comfort level about the frankness of the dialogue you can have and the conversations, and to get guidance, because it's scary, right? I mean, if it's the first time, it's not only it's and then the other thing to remember is don't take it personally. They're not robbing your house. You may feel like they're robbing your house, but they're not. I mean, it may be upsetting, it may be embarrassing, and as I can tell you, as a neutral or as someone who's co-founded a legal engineering firm, we don't do we're pretty picky, and frankly, we don't do a lot of IR except for like a handful of customers that we've worked with for years. It's intense. It's very intense, and you've got to gauge that, and you've got to slow it down so that your culture. Tech people will barge in with a total disregard for the culture and be very abrasive, and that may off-put the people that they need to work with the most. So I encourage everybody, especially if you're in the senior leadership position in cyber, to set the tone, right? Let's collaborate. And tell your vendors, control your vendors, saying, this is what I expect. This is how I need you to communicate. You got to have legal, set that cadence early, because if you don't, they'll set it for you. And they're putting out a fire. They'll kick the windows down, they'll break the vases, they'll do whatever's necessary to put out the fire unless you set a cadence.
Right. Do you know, our worlds are so intertwined, and yet I'm having that feeling. You remember when you were a kid and you had that feeling for the first time when you looked through a telescope and you went, oh, I'm just on a spinning ball of rock and there's all this other stuff out there. And guess what? All this other stuff is so much bigger than the world I live in. I'm in this little microcosm of a world. I talk to you and I think, gee, that's right. First call should be to a lawyer when you're under incident response, right? So talking of incident response plans, number one should be.
Let's start with the basics. You need one.
You need one, right? Yeah, you need one. So get one. And if you have one, you should dust it off because you probably haven't looked at it for a while. And then maybe number one should be call lawyer.
Or call your in-house lawyer, or call your risk, or whatever's reflective of your culture or your business, right? But just remember, if it happens in the United States and you want privilege to apply, you're going to need to have counsel involved.
Right. Yeah, exactly.
But I mean, you make an excellent point. I mean, it's, an incident response team is doing their job. But if you don't set the cadence and define how evidence is collected and how you want to engage and these other things, they're going to do it for you. Right. And that may not be reflective of your culture or the other pieces of your business. And, a general counsel isn't going to know what the difference is between compromise and access and, containment. What's containment mean, right? Containment, to some people means that you can operate your business without ransomware taking you offline, but it doesn't mean you're not going to have data leaks. Right. And so defining these terms and figuring them out is really a critical part, even when you're handling an incident.
Yeah, there's the very buzz right now, risk-based cybersecurity approach, right? So, and I'm pleased actually with the conversation. It's going more toward not if, but when you have a false positive. Let's make sure we have them on stuff that, we can manage a false positive for an hour or two, a downtime. You're a trader on a bank on the floor. We can't do an hour or two, right? So we should be prioritizing, the areas in which we have, let's say, fall prevention, where we have a higher risk of false positives, but in the area of the business which will have the least amount of impact, and then not to have the same false positive again. That's a much more realistic dialogue. So,
right. I mean, it's just about making money, right? I mean, you're in the business of making money, so manage the risk accordingly, right?
Yeah.
Kid's not going to school for a day, may have a personal loss to the parent who's a trader who may make poor trades that day. But the truth is that his system's still secure and operating versus his system's completely locked out and he can't trade and they're trading on his account. Like that has real implications. So understanding and managing that risk. A lot of people, and I call it common sense, but I mean, maybe for a lot of organizations, understanding their risk profile is a challenge. When I'm teaching at Rutgers, I tell people the law has lots of little details. But when you're in the middle of an incident, unless you have a photographic memory with instant recall, it isn't going to be as effective as you think. So having thought it out and thought about the risk profiles and the risk management is really important for lawyers to put on that business hat of their client, because sometimes lawyers have huge risk aversion. They're like, well, it may have happened. I'm like, no, that's probably a false positive, because only 14 megabytes are going, or 20 megabytes are going outbound an hour, and the zipped up files is 30 gigs, and we see the total traffic over that time is nominal, so it's probably a false positive or whatever, right? But being able to have those conversations and have them practically, and being able to articulate them close to the business and to the legal team and to the risk team and the insurance team. But a lot of people like controls. Like, it's astounding to me that like global banks and institutions still struggle today to, I've worked for global banks in that technical capacity, right? I mean, putting in those controls is one of the most critical things, because there's all these downstream impact around security, compliance, risk, oversight, and executing that is really important. But yeah, they call it risk-based now. They got all sorts of fancy.
Yeah, exactly. Well, in your opening comments, you mentioned it's nation states, and Russia allegedly attacking the Ukraine, the fallout from NotPetya. Okay, this was interesting, because back then, I think I'm going to get this roughly right. It cost FedEx about $280 million. I think Merck, the pharmaceutical manufacturer, was down for about 2 weeks, and it cost them $1 billion. So big fallout. Now, what I heard was there was a consortium of these CISOs saying, okay, we've got to get together and do something about this. I sort of see this as the citizenry, gearing up. I'm not sure that that's what we want. What can
definitely don't want?
Right. What can governments do then about fallout? So
that's a great question. And our government is doing something. I mean, Chris Inglis and Frank Kuflo, the Solarium Commission has, I don't know, like 100 legislative. There's a lot. The government is trying to address these issues and risks in a meaningful way. And the Solarium Commission has been in play, and they have a bunch of legislative proposals to help corporations. But under no circumstance do I want some of the CISOs I know leading the charge to do anything, because it's not the military. It's just simply not. So, I mean, from where I sit, like, you got to use common sense, but like, it's just a bad idea, right? There's legal and business implications, right? You could be hacking your partner. You think, oh, NotPetya comes from here. We're going to, like, good luck suing the Russian government. Like, seriously,
right,
good luck.
Right, yeah.
Like, let me know how that works out. What cause of action could you possibly bring and enforce a judgment that would be effectively, A, not harm your business, B, be able to prove beyond any reasonable doubt in a court of law, and not have other implications. Whether they did or didn't is separate, but it's the job of the United States government to figure out a way to effectively work with the private sector, creating more effective security, information flow, legislative, like legal structures that allow for quicker and access to remediate and respond.
Right. So as a personal philosophy of loving a small government, this is actually where I think government should take a play, right, in protecting our businesses. So what can be done? What does the future look like? And we're going to have to wrap in about 5 minutes.
So I mean, the future, who knows? I don't even know what's going to happen in November, let alone like,
Yeah.
I mean, what's the future look like? I mean, it's going to be, you can't stop time, and I'm blessed and I'm healthy. So, I mean, the future will be interesting. It'll be dynamic. I think you'll see a tighter relationship form between first off, there's no cyber cops. So like, we have police departments everywhere, and they enforce laws. Well, we don't have cyber equivalent of policemen that at a wide enough scale in the United States to even effectively even attempt to play ball in this.
Wow, good call.
And so I think you're going to see an emergence in that space. And then I think you'll also see international law is one of these tricky things, right? You want to do it, but you don't want other people to do it, and figuring out the right level of response. And, it's going to be interesting, because every country has different postures, and they're dictated by their governments and the people that are leading them, right? So it's hard to say, but I think you'll see the international business community at least saying, hey, look, enough's enough. But they've been saying that for a while. And I think he'll be left to each country to figure out how they do it. I think in the United States, you'll see a stronger emergence in relationship between the state helping companies secure themselves. It'll sort of be like there'll be a level of threat protection the United States government will eventually provide to not only the Fortune 500, because they represent a small portion of the economic output of the country, like hiring people, like small businesses, right? Like,
right. Yeah.
You know, and I think we'll see a tighter relationship of helping secure corporations, but there's a balance of privacy issues. So there's a lot of things to work out, you know, between how do you help a company secure itself if it doesn't want to share any information or visibility? How do you help secure or respond to an incident if you can't get the logs, right? And so there's this, you know, relationship building exercise I think will go on for the next 3 to 5 years between the private sector and the government at the state, the federal, local level to sort of figure out what's work. In New York, we have the New York City, there's a CISO, he's a fantastic guy of the city of New York. And I mean, New York has this cyber initiatives and cyber this and trying to help secure the citizens and whatever. And you're seeing I think it's infancy. I think you'll see it become like the police almost in some sense, or the fire department.
It's a great call. Yeah, I think it's going to have to be. Daniel Garrie, I could talk to you for another hour, so I'm quite certain that all the audience would like to hear more. Where can people find you online if they need help?
That's a fantastic question. Just the best way is just Google me and then reach out and I'll be accessible. I mean, you could go check out. That's probably the best way. I would also encourage people to come to the conference, which is converted to a lecture series. It's conference.jlcw.org. With some of the top leaders in the world and on these different topics, because there's a lot of smart people and it's always an opportunity. So I would encourage, but you can Google me or you can go to the conference and learn that way.
Yeah, so Journal of Law and Cyber Warfare, ladies and gentlemen, jlcw.org, right, Daniel?
Yeah.
You can go there, go Daniel Garrie LinkedIn Manhattan, Daniel Garrie Manhattan on LinkedIn, you'll find you. And definitely a shout out to your conference. In fact, you were kind enough to invite me a couple of years ago. I loved it. And that is probably a great place for people to go to. Daniel, I'm very grateful to our audience members. I always love to give a shout out to cybertalk.org, where we'll be hosting this as a archive conversation. We'll also throw up some assets there. There'll be some assets in the Bright Talk platform we're using right now. If you go to attachments, you can find some information there, which will help you on your journey. Ladies and gentlemen, good luck. Daniel Garrie, thank you.
Thank you, Eddie, so much. And thank you to Cyber Talk and everybody. And thank you to your audience. Thank you again. Wonderful. Have a great day.
All right. Take care, everyone. Thank you, Daniel.
Take care. Bye.